Hello, my name is Professor Shiladitya Rakshit, Environment 2 module. Learning outcomes. To give students an overview of the role played by the various courts in the protection of environment and human rights. By the end of the module, students will have an understanding of the role of public interest litigation in the developing of environmental jurisprudence in India. Introduction. Key doctrines evolved in environmental litigation. While treading the path of judicial innovation, the Supreme Court has invented an impressive range of concepts and principles. The principles of strict and absolute liability, the principle of sustainable development, the polluter pays principles, the precautionary principle, and the public trust doctrine have thus found firm footing in Indian jurisprudence. The precautionary principle. Precautionary principle plays a significant role in determining whether development process is sustainable or not. Precautionary principle is principle which ensures that a substance or activity posing a threat to the environment is prevented from adversely affecting it, even if there is no conclusive scientific proof lining that particular substance or activity to the environment damage. The onus of proof is on the actor, developer, or industrialist to show that his action is environmentally benign. In Velo Citizens Welfare Forum vs. Union of India, Tamil Nadu Tanneries case, the Supreme Court has recognized sustainable development, the precautionary principle, and the polluter pays principle as part of our environmental jurisprudence. It was also observed that the precautionary principle or polluter pays principle are part of environmental law of the country relating to the constitutional provisions contained in the Articles 21, 48A, 51AG and other statutory enactments such as Water Prevention and Control of Pollution Act 1974, Air Prevention and Control of Pollution Act 1981 and the Environmental Protection Act 1986. In this case, about 900 tanneries in 5 districts of the state of Tamil Nadu were discharging enormous amount of untreated effluent consisting of about 170 different types of chemicals into agricultural fields, roadside waterways and open land. About 35,000 hectares of land became partially or totally unfit for cultivation. The water in the area became unfit for consumption and irrigation purposes. In this judgment, Justice Kuldeep Singh, known to be a green judge, observed that even otherwise, once these principles are accepted as part of the customary international law, there would be no difficulty in accepting them as a part of the domestic law. It is almost accepted proposition of municipal law that the rule of customary international law, which are not contrary to the municipal law, shall be deemed to have been incorporated in the domestic law and shall also be followed by the courts of law of the country. The Supreme Court also recognized the precautionary principle, which is one of the principles of sustainable development. In MC Mehta versus Union of India, the Supreme Court observed the precautionary principles and the polluter pays principle have been accepted as a part of the law of the land. In this case, public interest litigation was filed alleging that due to environmental pollution, there is degradation of the Taj Mahal. a monument of international reputation. According to the opinion of the expert committees, the use of coke/coal by the industries situated within the Taj Trapezium Zone (TTZ) were emitting pollution and causing damage to the Taj Mahal, as also people living in that area. In the instant case, the court ordered the location of polluting industries. In MC Mehta 2 versus Union of India, the Supreme Court directed all the municipalities located on the banks of the river Ganga to take preventive measures for water pollution. The court held that the municipality was primarily responsible for the pollution in the river and was not only obliged but also bound to take steps to decrease as well as to control the pollution. The Supreme Court in MC Mehta versus Union of India had given direction to the Delhi city authorities to take effective steps for streamlining vehicular pollution in the city. The order of the Supreme Court prohibiting the use of 20-year-old vehicles in the city roads of Delhi and its implementation is a welcome step in prevention of the vehicular pollution, avoiding the accident and protecting health of the Delhi police. In Shobha Ramaya Subramaniam versus the Member Secretary, Chennai Metropolitan Authority, the court stated that the construction builders have a duty to use modes for digging foundation for multi-story building so that it does not cause noise pollution in the neighboring areas. In S. Jagannath versus Union of India, the Supreme Court held that sea beaches and sea coasts are gifts of nature and any activity polluting the same cannot be permitted. The intensified shrimp, prawn farming culture, industry by modern method in coastal areas was causing degradation of mangrove ecosystem, depletion of plantation, discharge of highly polluting effluents and pollution of potable as well as groundwater. Polluter pays principle. It's a principle in international environmental law where the polluting party pays for the damage done to the natural environment. In Indian Council for Enviro Legal Action Others versus Union of India, the Bichari village case, the Supreme Court accepted the polluter pays principle. It was said, the polluter pays principle as interpreted by this court means that the absolute liability for harm to the environment extends not only to compensate the victims of pollution but also the cost of restoring the environment. Degradation, remediation of damaged environment is part of the process of sustainable development. The Supreme Court held that as per the polluter pays principles, once the activity carried on is hazardous or inherently dangerous, the person carrying on such activity is liable to make good the loss caused to any other person by his activity, irrespective of the fact whether he took reasonable care while carrying on this activity. The rule is premised on the very nature of the activity carried on. The Supreme Court cited with approval the following passage pertaining to the polluter pays principle. The polluter pays principle demands that the financial costs of preventing or remedifying damage caused by the pollution should be with the undertakings which cause the pollution or produce the goods which cause the pollution. Under the principle, it is not the role of government to meet the costs involved in either prevention of such damage or in carrying out remedial action, because the effect of this would be to shift the financial burden of the pollution incident to the taxpayer. Adopting this principle, the Supreme Court directed that the task of determining the amount required for carrying out the remedial measures, its recovery realization, and the task of undertaking the remedial measures is placed upon the central government. It was directed that the amount so determined should be recovered from the pollution and the polluting industries. M.C. Mehta versus Union of India and others, the Calcutta Tanneries case, the polluter pays principle relating to relocation of industries was applied with direction to those relocated industries to pay 25% of the cost of land. Those who did not pay for the cost of land were directed to be closed. The principles of strict and absolute liability. The general rule of tortious liability relates to international wrongdoing or negligent wrongdoing. An exception to this general rule of tortious liability has been made in the case of Ryland versus Fletcher. The rule in Ryland versus Fletcher is a rule of strict liability. That means such a rule does not require proof of negligence, lack of care, or of wrongful intention by the defendant. There are certain exceptions to the rule of absolute or strict liability laid down in the case of Ryland versus Fletcher. The exceptions are as follows: that is, act of God vis major, default of the plaintiff, consent of the plaintiff, volunty non fit injuria, act of a stranger, statutory authority. For the purpose of conservation and environmental protection, and also to encourage and ensure environmental jurisprudence, the exceptions to the traditional common law doctrine of strict or absolute liability established in Ryland versus Fletcher were rejected. Absolute liability in its basic sense refers to no-fault liability, in which the wrongdoer is not provided with exceptions which are provided in the rule of strict liability. Absolute liability is more stringent form of strict liability. The rule laid down by Rylands versus Fletcher and was recognized by the Supreme Court of India in M.C. Mehta versus Union of India, the Oleum gas leak case. Finding the rule of strict liability as laid down in Rylands versus Fletcher to be unsuitable for dealing with enterprises engaged in hazardous or inherently dangerous activities in the country. The Supreme Court unanimously held in M.C. Mehta and others versus Shriram Food and Fertilizer Industries and Union of India case that where an enterprise is engaged in a hazardous or inherently dangerous activity and harm results to anyone on account of an accident in operation of such hazardous or inherently dangerous activity resulting, for example, in escape of toxic gas, the enterprise is strictly and absolutely liable to compensate to all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate vis-a-vis the tortious principle of strict liability under the rule of Rylands and Fletcher. Justice Bhagwati also stated that the rule of strict liability was evolved in 19th century, the time when nature industrial developments was at primary stage. In today's modern industrial society, where hazardous or inherently dangerous industries are necessary to carry out development programs, thus the rule cannot be held relevant in present-day context. Also, one cannot feel inhibited by this rule, which were evolved in the context of totally different social and economic structure. Thus, the apex court, by departing from the rule of strict liability as laid down in Ryland versus Fletcher, took an epoch-making decision having wide ramifications. It is to be noted that this judgment opened a new frontier in the Indian jurisprudence by a new concept of absolute liability standard, which is not subject to any exception for industries engaged in hazardous activities. The principles of sustainable development. The Brundtland Report defines sustainable development as development that meets the needs of the present generation without compromising on the ability of the future generations to meet their own needs. The report emphasizes that sustainable development means an integration of economics and ecology in decision making at all levels. The judiciary in India has played an important, innovative and creative role in interpreting the laws with judicial activism in such a manner that they help not only in protecting the environment but also in promoting sustainable development. In a series of path-breaking judgments towards the end of 1996, the Supreme Court incorporated some of the important environmental norms, notably principles of sustainable development, the polluter pays principle and the precautionary principle as part of the land, while rejecting the old notion that development and environmental protection cannot go together. The Apex Court held the view that sustainable development has now come to be accepted as a viable concept to eradicate poverty and improve the quality of human life by living within the carrying capacity of the supporting ecosystems. Thus, pollution be commensurate with carrying capacity of our ecosystem. Thus, the court further held that the polluter pays principle and the precautionary principles are essential features of sustainable development. In Kinkari Devi versus State of Himachal Pradesh, the Himachal Pradesh High Court observed that if industrial growth sought to be achieved by reckless mining, resulting in loss of life, loss of property, loss of amenities like water, supply, and creating of ecological imbalance, then there may ultimately be no real economic growth and no real development. In People United for Better Living in Calcutta versus State of West Bengal, the Calcutta High Court observed that it is true that in a developing country there shall have to be developments, but that development must be in harmony with the environment. There has to be a proper balance between the economic growth and environment so that both can exist without affecting each other. The Supreme Court in AP Pollution Control Board versus M.V. Naidu observed that in order to ensure that there is neither damage to the environment nor to the ecology and at the same time ensuring sustainable development, it can refer scientific and technical aspects for investigation and opinions to statutory expert bodies having combination of both judicial and technical expertise in such matters. The Supreme Court in M.C. Mehta versus Union of India observed that the development and the protection of environments are not enemies. If without degrading the environment or minimizing adverse effects thereupon by applying stringent safeguards, it is possible to carry on development activity applying the principles of sustainable development. In that eventuality, the development has to go on because one cannot lose sight of the need for development of industries, projects, etc., including the need to improve employment opportunities and the generation of revenue. A balance has to be struck. In N.D. Jayal versus Union of India, the court held that the right to clean environment and the right to development are integral parts of human rights covered by Article 21 of the Constitution. The court laid down that the principle of sustainable development is a means to achieve the object and the purpose of the Environment Protection Act 1986 as well as protection of life envisaged under Article 21 of the Constitution. Public Trust Doctrine. The public trust doctrine primarily rests on the principle that certain resources like air, sea waters, and the forests have such a great importance to the people as a whole that it would be wholly unjustified to make them a subject of private ownership. The said resources being a gift of nature, they would be made freely available to everyone, irrespective of the status in life. The doctrine enjoins upon the government to protect the resources for the enjoyment of the general public rather than to permit their use for private ownership or commercial purposes. The Roman law recognized the public trust doctrine whereby common properties such as rivers, seashore, forests, and the air were held by the government in trust for free and unimpeded use of the public. These resources were either owned by no one, res nullius, or by everyone in common, res communius. This doctrine came up for consideration in the M.C. Mehta versus Kamal Nath. In this case, the flow of the river Bias was deliberately diverted because it used to flood span motels in the Kudu-Manali valley in which a prominent politician's family had a direct interest. The motel was also allotted protected forest land by the state government and had also encroached on protected forest land, which encroachment was subsequently regularized. The Supreme Court used the public trust doctrine in this case to restore the environment to its original condition. Briefly, the doctrine postulates that the public has a right to expect that certain lands and natural areas will retain their natural characteristics. Applying the public trust doctrine, the Supreme Court cancelled the lease of forest land granted in favor of span motels, and the state government was directed to take over the area and restore it to its original condition. The motel was directed to pay compensation, damages for restitution of the environment and ecology of the area. It was also asked to show cause why a pollution fine be not imposed. While deciding the show cause notice regarding imposition of a pollution fine, the Supreme Court held that in law the fine could not be imposed without a trial and a finding that the motel is guilty of an offence under the Water Prevention and Control of Pollution Act 1974. Accordingly, no pollution fine was imposed on span motels, but was asked to show cause why it should not pay exemplary damages. After considering the reply of span motels, an exemplary damage of Rs 10 lakhs were imposed. In MI Builders Private Limited versus Radhe Shyam Sahu, Lucknow Nagar Mahapalika permitted MI Builders Private Limited, the appellant herein, to construct an underground shopping complex beneath the Jhandilwala Park. The major part of the work was completed. The High Court quashed the relevant resolutions that permitted the construction when it set aside the agreement. The High Court had noticed certain facts. The park was of historical importance, which the Mahapalika did not deny. Preservation or maintenance of the park was necessary from the environmental angle. The only reason advanced by the Mahapalika for construction of the underground commercial complex was to ease the congestion in the area. The High Court said that construction of the underground shopping complex would only complicate the situation and the present scheme would further congest the area. The builders appealed. The Supreme Court went on to say that Mahapalika is the trustee for the proper management of the park. When the true nature of the park as it existed is destroyed, it would be violative of the doctrine of public trust as expounded by the court. The court quotes the idea of public trusteeship rests upon three principles. Firstly, certain interests like the air and the sea have such importance to the citizenry that it would be unwise to make them the subject of private ownership. Secondly, they should be made freely available for the entire citizenry without regard to economic status. Thirdly, it is principal purposes of government to promote the general public rather than to redistribute public goods from broad public use to restrict private benefit. Concluding remarks. It is to be noted that the right to the environment is a comprehensive right like any other basic right at both national and international level. The Supreme Court has interpreted the various constitutional and legal provisions relating to environment in an appropriate direction by promoting ecological balance and sustainable development. The judiciary reasserted the right to pollution-free environment as an integral part of the right to life under Article 21, asserting that human rights are to be respected. The Supreme Court has, during the course of various decisions, emphasized that the protection of environment is a constitutional objective. The growing menace of environmental pollution is a formidable challenge to the human race since it affects the lives of billions of people across the world. It would be seen that continuous efforts are being made by the legislature, executive and judiciary to control and prevent water, air and noise pollution in order to preserve environmental and ecological balance. But these efforts can bear fruits if they get the necessary public cooperation and support. After all, the sources of environmental depletion, no doubt, the matters relating to environmental problems are brought before the courts by public-spirited persons and voluntary social agencies. But the courts have their own limitation, necessary directions to the executive or order removal of the cause of pollution which is damaging the environment. But the empowerment, therefore, has to be ensured by the executive authority, and much of it is depending upon the public willingness to cooperate in this endeavor. Thank you.